So today we would like to discuss legal realism. So we try to have a very lengthy introduction, putting it in context, what legal realism actually means, the two approaches to legal realism. We'll try and draw the distinction between them at the very outset. And when we're done with that, we will proceed to discuss the nuances or the details of each of these two schools. And we have like a general critique, and we are done with legal realism. Legal realism as a school of legal philosophy is very recent compared to the two major traditions, natural law school, legal positivism, as we know. And legal realism emerged on the scene in the early part of the 20th century. And of course, it was popular in two main countries, the United States of America and also the Scandinavian. What does legal realism seek to do? It questions or challenges the formalist notion. Those who believe in legal formalism, that legal decision can be derived from statutory or constitutional tests. Some scholars believe that legal rules, especially if you look at the various adherents of a legal positivism, that to know the law is the matter of studying the various legal materials out there, and you'll be able to extract principles, making use of logical tools of reasoning and all that. Now, legal realism rejects all that and rather say that the truth of the matter is that judges often base their decisions on personal, social, and political factors. And for that matter, if you want to understand law, our focus, our emphasis should not exclusively be on just the traditional legal materials, but we should go beyond law. We should go beyond the traditional legal materials to understand the personality, to understand the society, the social circumstances, the political circumstances of the courts, so that we have a good idea of the direction in which the law moves. So that is basically what legal formalism seeks to help us to understand. So the legal realist typically rejects any attempt to place law into categories which has no basis in reality. So therefore, for them, it doesn't make sense to talk of things like, let's say, justice. The justice is just empty, or absolute justice is empty. They rather want things which can be reduced into practical terms, empirical terms, something that you can measure, something that you can feel. So realism is more concerned with law as it is. I mean, to put it very simply. So law as it is, rather than law in theory. So they are interested in, if you like, law in action, the law as it is, rather than law, what the law is in theory. So it preoccupies itself with the actual operation of law in this social context. So it's not enough to say that this is the law or that is the law, but the legal realist is interested in if you look at the law, it's being applied. How is it? That is what we're interested in, and not just the law sitting in the, the statute books or in the law reports, as it were. So therefore, the realists will opine that there is more to law than what is cloaked in legal rules and principles. So when I give you a very good example of what we are witnessing in our country. You take matters to the Supreme Court, and we know the law in the books, isn't it? So ordinarily one will say that, okay, if this is what we know is in the books, then this should be the outcome. No, it doesn't work like that according to the realists. The realists will say that we have social circumstances, economic circumstances, political circumstances, and some realists, especially the Scandinavians, will say that we even have like a psychological circumstances forming an important context within which the law operates. So if you want to really understand the law, you should pay attention to all those matters as well, and not just the hard rules we have in the book. And realists, again, are very much aware that legal rules are often vague, abstract, and contestable. And that is why interpretation is there. So the fact that law is not free from vagueness, is not free from abstraction or ambiguity, means that there's a need for interpretation to be done so as to know the true position of the law at every moment in time and also in every situation. And as they say, the devil is in the details. Now, where you're going to do the interpretation, that is where the trouble begins. Because in that case, we don't know the position of the law yet until, let's say, the interpretation is what is done. And within the context of that exercise is where the judges, social realities, political realities, economic realities, psychological realities will feed into the exercise. Realists again note that judicial precedent is not enough. It's not enough just to say that, for us, we operate the stare decisis, the common law doctrine of judicial precedent. And for that matter, if there's a problem, all that we need to do is to try and find out in the law reports, in the reported judicial decisions, whether there is any case which speaks to the situation that we have on hand, so that it will just be a matter of going to that case, read it, and know how the courts resolve it. And that should give you a very reasonable idea of the most likely outcome of the case that you have on hand. So that is why they said that judicial precedent is not enough, because in their view, sometimes judges do not apply rules or principle mechanically, but use their discretion in their judgments. So the fact that discretion is there, and discretion simply means that the judge is given a latitude, a bit of a room to maneuver, and then he or she can make choices and justify them one way or the other. So the fact that we have a discretion according to realists means that judicial precedents do not assure us of the legal certainty which we think judicial precedent will assure us. Yes. Okay, so I've made the point that we have two main aspects of legal realism, or two main branches. The one which originated from the US called American legal realism, and then one which originated from the Nordic called the Scandinavian realism. So let's just suppose the two before we come to take each of them and discuss more of each. Now, the American realism focuses mainly on practical application of law and the role of judiciary in shaping legal outcomes. So for them, the role or the work of judges is so crucial in trying to understand law. And American realism holds the view that law is not a set of abstract rules, as we've indicated when we're talking about all of them generally, but is influenced by social, political, and economic factors. So look at the United States, for example, what is going on. We know what happened, 6 January, this is 2021, and we know implications for American laws and all that. But then we also know that we still have a significant segment of society that sees things differently. And various cases have been taken to court against certain individual or persons. And American realists will say that law is not just a set of abstract rules, but influenced by social, political, and economic factors. So some of the key proponents of the American realism: Oliver Wendell Holmes Jr., Karl Llewellyn, Jerome Frank, and they all emphasized the unpredictability of judicial decisions. The fact that you cannot tell ahead of time with reasonable certainty how cases are going to be decided. And they also emphasize the importance of empirical and sociological methods in legal studies. So, law and society, law and economics, these are approaches to learning law, which actually have their origin from what we called the American legal realism. Because if the conviction is that it's not just about the abstract rules, but it's about the law in action, then your approach towards learning law should also not just be doctrinal approach only. It should not just be doctrinal approach. If I say doctrinal approach, what I mean is that it's not enough for you to use a black letter approach to law, where you just look at the legislation, where you look at the decided cases, and you use that to make your various inferences, extrapolations, and conclusions, and say that you know the law. No, they says that you need, if you appreciate that social, political, and economic factors influence how law plays out in action, then in trying to learn law, in trying to study law, you must also use methodology or approach which would enable you to be able to keep track of those factors and know how they influence law. And that is why empiricism, sociological methods of inquiry are very important to these American realists. So what are the key features? So we see the key features of American realism as opposed to Scandinavian realism. American realism, there's this emphasis on judicial pragmatism. Judicial pragmatism, their idea or the belief that judges often make decisions based on practical wisdom and experiences rather than solely on legal precedent or statutes. So that is to say that judges are supposed to be more practical in the way they do their adjudication rather than thinking that they just use mechanical application of some rules of logic based on legal precedent and statutes. No. And some will even go and make the claim that when it comes to adjudication, judges as practical or pragmatic people may have their own intended destination they want to arrive at. And all that they have to do is to find out how do I get the rules or the tools that will help me to rationalize the particular destination that I want to arrive at with respect to the adjudication that I am doing. So there's that emphasis on judicial pragmatism. Then empirical analysis. Yes, certainly. Once they emphasize judicial pragmatism, then they would advocate for use of social science techniques to study law and legal institutions. So therefore, the various social science and methodology, collecting data, talking to people, observing people, and so on, in relation to operation of law, in relation to how the legal system and its various components function become very important. Another observable feature of American realism as opposed to Scandinavian realism is that they see law as a social tool. Law is an instrument for social change, or as they put it, social engineering. It's an instrument for social change or social engineering, as it were. And for that matter, law can impact on society in a significant way. The Scandinavian realism, on the other hand, which originated from the Nordic countries, Denmark, Norway, Finland, and so on. And for that matter, also known as the Nordic legal realism. The major figures over there, or the proponents, we have Axel Hagerstrom, Alf Ross, Vilhelm Lundstedt. The Scandinavian realists, they move in a different direction from American realism by emphasizing or focusing more on the linguistic and philosophical aspects of law rather than the judiciary's role. So they are saying that law is actually carried through the instrumentality of language. And for that matter, all the things we know which influence language and so on also affect law. So unlike their counterpart in the US, where the emphasis is so much on the role of the judiciary or judges, they are also looking at some external factors of the law, but not necessarily just the judge only, as it were. So the observable features for Scandinavian realism, linguistic and philosophical approach. They stress the need for analyzing legal language and concepts, because they argue that legal rules are statements about behavior of legal officials and not objective truths. Legal rules are not objective truths, but just a statement about how officials in charge of society, in charge of the legal system will behave. And that is why they consider it necessary for legal language and concept to be analyzed. And if you remember, there's a little bit of coincidence with what we encountered when we're discussing Hart's concept of law. And very early part of his discussion, he will make the point that most of the problems that we have regarding the nature, the essence of law, interpretation of law and all that, has to do with the fact that law is carried through a certain medium. And what is that medium? The medium of language, okay? The medium of language. And we know that language has got its own challenges. What are those challenges? The fact that various words can have multiple meanings, layers of meanings, and so on. And for that matter, when you use them, you are definitely going to create a situation of what we call multiple meanings or ambiguity. And we are not so sure of exactly what is intended until another thought processes is engaged before we actually come to what the speaker intended and so on. So in that respect, we see the point of linguistic and philosophical approach, which Scandinavian realists actually rely on, also being reflected in Hart's concept of law to some extent. They also see legal science as a moral science. So the study of law is also about study of normative concepts. The study of conviction about what is good, what is bad, what is right, what is wrong, what is just, what is unjust. And they are also skeptical as far as metaphysical concepts are concerned. You know, if you look at natural law school and others, they emphasize so many ideas which are steeped in metaphysics. Metaphysics in the sense that those ideas are abstractions, you know, like you're making abstract claims, things that you cannot easily ground in reality. You cannot ground in verifiable or measurable, if you like, material, as it were. For example, you say that something is just, something is unjust. It's still abstract. you cannot, can you see justice when you see it? Or you say that the natural right, that you have a certain right, and those rights are inherent, those rights are inalienable, and so on and so forth. Those rights are there because you're a human being, and so on. These are all claims which are steeped in metaphysical or abstract reasoning, what we call the a priori reasoning. And Scandinavian realists are very skeptical towards some of these concepts. And they rather advocate for more of empirical and logical approach to legal analysis. We come and say more about each of these pretty soon. So still comparing the two, on the one hand, American realists see law as a legal science that predates how judges will decide cases. And that is how American realists, if you like, effectively see law. Their Scandinavian counterparts, or Scandinavian realists, on the other hand, see law as empirical knowledge of social facts. So you see that for them, they are not really looking at it in the context of courts or adjudication. Again, American realists are rule skeptics and behaviorists. Rule skeptics in the sense that they are doubtful regarding primacy of rules in understanding the law, as legal positivists, for example, will tell us. So that's why I said that they are rule skeptics. They don't believe that understanding law is equal to just knowing rules, the legal rules. And they are more, as we have been talking about, concerned also about the law in action, how the law is actually applied. And they will tell you that that one is influenced by so many factors. Scandinavian realists, on the other hand, are metaphysical skeptics. So they are doubtful. No, skeptics that you are doubtful. They are doubtful about the claim that metaphysics or metaphysical reasoning is important in trying to understand the nature of law. And in fact, they attack the metaphysical foundations of law. So therefore, American realists are more concerned with courts and how the courts operate. Scandinavian realists, on the other hand, they are concerned with the legal system as a whole. So they have, if you like, a more holistic view of the legal system with respect to the type of realism that they espouse. Whereas American realism is more, if you like, court-centric or judge-centric, just around the courts and then the judges. So if we wanted to do a bit of more thematic comparative analysis, in terms of focus, American realism is more concerned with actual practices of law and judicial decision-making. Scandinavian realism concerned with the linguistic and normative analysis of legal concepts. In terms of methodology, or in terms of approach, American realists, they use practical methods, empirical methods, to analyze or measure the law's impact on society. So, for example, recently, and in the news, we read that the Attorney General has written to the police or the police IGP or something like that, regarding how the police arrest people on the road for some minor traffic breaches and so on. So, you see, the law is there. Now, there are concerns about how the law is enforced or how the law is applied. So, in the same vein, you take the courts. If you take a judge, for example, whose close relation has been killed or injured by maybe careless driving, right, before, if a case of that nature is put before him or her to adjudicate, you can reasonably assume that unless significant high degree of restraint is exercised, his thinking, if he has any discretion to exercise in terms of sentencing, may be affected by his or her own personal experience. And that is what the realists, especially the American realists, they are telling us. Yeah, so we also noted that Scandinavian realists, they employ more of a linguistic approach to understand legal language and its implication. And in terms of legal theory and practice, American realism seeks to reform legal practice by acknowledging external influences on judicial decisions. You cannot reform the law, you cannot reform how the law is practiced, how the law is enforced, if you don't really understand, or if you don't acknowledge, if you don't accept that certain external influences operate when it comes to the way the courts actually work. On the other hand, Scandinavian realism is not so much about reforming the law, but they are interested in clarifying, helping us to understand legal reasoning, and also critiquing foundations of legal thoughts. So they emphasize that there's a need for a scientific and rational approach to legal theory rather than metaphysical reasoning. We make claims which cannot be subjected to proper logical analysis, as it were. So one thing you observe is that American realists, they are moving away from the idea that you can just use logical tools of reasoning to make sense of the law, predict the law, and all that. No, they are rather saying that you should accept that there are certain non-legal factors which affect the way and manner the law is applied, the law is interpreted, and all that. So you should study those things as well. Whereas the Scandinavians are also still going back to reliance on tools of logic and other things to try and make sense of the law. Yeah, and in the course of this model, you notice that we have certain offshoots, relatively recent legal theories like critical legal studies, CLS, critical legal studies like which including postmodernism and all that, race theory, feminist theory. These are all part of the critical legal theories. Those who, for example, say that if we look at society is a highly patriarchal, is male, for example, dominated. So it's male chauvinism is, for example, what has influenced the way society is constructed and all that. And for that matter, if you wanted to do justice, if you wanted to ensure that all members of societies are treated equally, we need to recalibrate and move away from that. And some will be arguing for, let's say, affirmative action and so on as a way of reversing some of these imbalances. So all these are some aspects of critical legal studies, and they were, propelled, they were influenced by the American legal realism. And the same thing also applies to another school we call the law and economics movement. The law and economics movement, the Chicago school especially, is an attempt to try and bring economic reasoning, economic way of understanding the world to bear on the law. As we know, economists are concerned about what they call efficiency, right? Economists acknowledge that we have scarcity as a problem in the world. Resources are limited, and resources may have alternative uses, and sacrifices will have to be made. But then, at the end of the day, are you achieving efficiency? Are you getting the best or the most optimal outcome and all that? So that is economic reasoning, and law and economics movement attempt to use this approach to also make sense of the legal system and also how the law works. And all these things, as I said, are offshoots from the legal realism as developed in the US. Scandinavian realism also contributed to development of legal positivism. So maybe if we look at the scholars like Kelsen, right, pure theory of law and all that, you notice that it is influenced by the way that the Scandinavian realists also look at law, as it were. So now let's say a few more words about each of these schools separately, and then we move on. So let's start with American realism. American realists, as we have indicated in the introduction, seek to put a more sociological account of law, that is law in action. So courses like law and society and so on, or what we call the sociological approach to law. They are all, if you like, a reflection of what we called American realism. So it is a rejection of the formalism of the positivists. You remember legal positivism, they remind us that The law is that which is posited, that the one which is put forward by whoever has authority to make law. And formalists will say that you have to look at the rules and then see how you can deduce logical patterns and all that, so that based on the logical patterns that you observe from the rules, you'll be able to make certain inferences, certain conclusions, and so on. Mm. So we said that they actually reject formalism. So formalism is the mode of legal reasoning which assimilates legal reasoning to syllogistic reasoning, syllogism in logic. You have your premises and then your conclusion. So legal rule plus relevant facts will give you judgments. So if you like, this is a typical mode of formalist thinking. Yes, what is the rule? The facts, judgment or conclusion. So just as we do in the, if you like, the IRAC, isn't it? When we are doing a problem-based question, that we know the rules, find the relevant rules, and then apply to the facts. You do your analysis, and then you have your conclusion. So that is sort of like a syllogistic reasoning. Now, American Realist questions this approach and says that this approach, this formalist approach, understates the power of the judge to make the law. It creates the impression that the judge is more or less like a robot, a very mechanical person, which is just applying the law, which is there in a very neutral fashion. But American Realist says that there's more to that. So the realists are preoccupied with empirical questions, practical questions, in an attempt to identify the sociological and philosophical factors which inform judicial decision making. So as I have pointed out, a judge who has been a victim of, let's say, armed robbery, or whose relative has been a victim of armed robbery, would always give maximum sentence to such criminals when they come to his or her court. So that is how the realists would actually reason. So here they are pointing to sociological and psychological factors which inform judicial decision making, and they reject the notion that judges are strictly constrained by legal rules and attach greater significance to the moral and political intuition about facts of a case. In fact, how the cases are, according to the realists, a lot depends upon interpretation. A lot depends upon the particular way the court would like to make sense of those facts and so on. And that is why they think that it's not just enough for you to look to the rules, but you should also look at the sociological, psychological, political context to understand what the courts are doing. Of course, let's say that there's a recent development in our country, Ghana, the case involving one MP that I don't pronounce the name well, but you know the case I'm talking about, where it was taken to the Supreme Court, and it has to do with the approval of the ministers and some of the standoff going on in Parliament, and how the case was fixed for hearing and generated some unnecessary discussion in the public space. And you get the courts, the Attorney General also coming out to explain how the courts actually work. You take your case there, the fact that you have to look at the rules, you have to follow through to make sure that if it's expeditious hearing that you want, then you get that and all that. So these are some of the relatives American realists are pointing to. And of course, we have cases which have implication for governance, right? So some cases might have been filed maybe 2 years ago. Probably they haven't had a slot in terms of being slated for hearing. But you have some cases which have been filed, probably not too long, but because of the implication they have on governance and national security, it may not be out of place for them to be given expeditious hearing so that we know the outcome one way or the other, and then governance can move on and so on. So we can extract some few more points from American realism. So one, the conception or the idea of law in flux, the fact that law does not stand still. Law is moving. Law is dynamic. And for that matter, judicial creation of law, that judges actually make law as it were. And that is why they say that don't just look at the rules which have come from Parliament, the Act of Parliament, right? Wait until the judges have pronounced upon it, the judges have applied it before you understand the law. Another point is that American realists also have this conception of law as being a means to social ends and not as an end in itself. The law is not an end in itself, but it is a means to what? A social end. You want to achieve certain objectives for society. That is what matters. And law should be used insofar as it helps you to advance those objectives or attain those objectives. Again, American realism is also based upon the idea that society in flux is faster than the law. That is, changes happen in society. Flux means changes, dynamism, movement, right? That changes happen in society happens faster than changes which occur in the law. So changes or development in society is always ahead of the law. Again, they also, of course, go back to the original is and ought question, say that the is should be separated from the ought for purposes of study. And that is why they say that they are interested in the law, what the law is in action, rather than what the law is in the statute books or the law reports. So again, the American realists are quite distrustful of traditional legal rules, as we have been saying, and concepts they maintain mere description of what the courts or people actually do. So we shouldn't stop at concept. We shouldn't stop at doctrines, but we should just see them as being a description of what the cause or what people connected to the court would do. Yeah, so the realists also, American realists also distrust, or they do not have faith in the traditional way of prescribing rules. In other words, if you look at the traditional approach, legal positivism, right, they will hold the view that, yes, the courts also lay down rules through their precedents. And the precedents are supposed to tell us how the law should be applied in future. Now, American realists believe that it's not that simple. It's not just a question of having precedents and you are sure that if this is the precedent, then this should certainly be what would happen. Yes, there's some truth in it, but it's not all the time. They also believe in grouping cases and legal institutions into narrower categories rather than having just a broad categories out there. And for that matter, they insist on evaluating law in terms of its effects. And that means that they reject black letter law approach, legal doctrinal approach. The black letter law or legal doctrinal approach means that you look at the law as in the statutes, the law as in the law reports, and try and discover patterns in terms of logical patterns, coherence, and all that. But American realists say that, no, what is really important is the effects of the law, the impact of the law. And you will not know the effect or the impact of the law until you go beyond the law and look at application of the law, what is doing in society, what is doing in people's life. That is what is important for the American realists. And for that matter, they encourage sustained and programmatic attack on problems of law, that we should regularly be evaluating law to find out how it is doing in terms of how it's shaping lives, society, and all that. So let's take a few of the proponents in American legal realism. And you cannot talk of American legal realism without Justice Oliver Wendell Holmes. So if we take Oliver Wendell Holmes, for example, he was a scholar and also a judge, and his approach to law, legal scholarship and adjudication, by and large, influenced the emergence of what we call American realism. According to Holmes, the examination of facts must be the basis of jurisprudence. So jurisprudential concepts which are not capable of verification must be rejected. In other words, you cannot have claims which cannot be verified. which cannot be proven empirically. Such concepts, according to Holmes, are not worth engaging the attention of the jurists. So Holmes argued that the life of the law is essentially experience. Political and moral theories, intuitions of public policy, and prejudices, which judges share with their fellow men, are far more important than syllogism in determining the rules by which men are governed. Syllogism here refers to logic, like logical approach. Logic is like we have the premise. If X, then Y. Or if S and Y are this, then Z will follow. So that is syllogism. That is a logical pattern. And he is saying that that is not what is important when we are talking about law. But what is really important is experience of people involved in the law. What prejudice do the judges or the courts have? And how do they influence the way that they shape society? Holmes was a firm believer in the distinction between law and morality. And he made the point that in the study of law, there should be deliberate exclusion of every word of moral significance, as these have little consequence in any analysis of operational matters. Now, Holmes will make the point that the law is actually what the court say it is. And that is why in his famous book, The Predation Theory, you see that the bad man's view of the law. What he cares about, what will be like the consequence of the law when he breaches the law, rather than what the law says. So it is a set of consequences emerging from the practices of the courts. It's not a system of reason or an amalgam of deductions from ethical principles. Just a second. Yes. Yeah, so according to Oliver Wendell Holmes, as we've indicated, the law is actually what the court says it is. And of course, that may raise implications for you on what you understand by democracy and also separation of powers, especially when we know that it is the province of the lawmakers, that is parliamentarians, to make the law, and then for the judges to enforce or apply the law. But going by Oliver Wendell Holmes' thinking, we don't know the law when parliamentarians have made the law until there has been application or pronouncement on it by the courts before we can know the law. I mean, that is what he is teaching us. So therefore, Oliver Wendell Holmes made the point that to know what the law is, one must look at the bad man. What do you call like his prediction theory? The bad man who cares only for the material consequences. The material consequence, that is to say that for him, okay, when I am in breach of the law, what will be the effect of the law for me? Yeah, so that is the thing. And in terms of contribution to development of American legal realism, Holmes is credited with the pragmatism or the practical or pragmatic approach to law. And as we have indicated for him, we should rather look at the practical effects of the law rather than the abstract principles. And that is what is driving legal realism. And this is to the credit of Oliver Wendell Holmes. And that is why we have this popular saying, the life of the law has not been logic, it has been what? Experience. And this is a statement which Oliver Wendell Holmes made, and it's a statement which is a testament or a reflection of what he believed the law was about, or the law is. And that is why I say that it's not about logic. It's not about looking at the rules to see if you can derive or observe certain logical patterns in the rules. And then you use that to solve problems. No. He said that you should rather look at the lived experience. That is what will tell you what the law is. And if you look at the formalists who place so much emphasis on statutes and case law, for them, what is important is statutory interpretation, how judges interpret the law, and also how they use the doctrine of stare decisis or judicial precedent. But Holmes' approach would stress the importance of real-world outcomes and lived experiences of people as that which really matters. Then he did a lecture, and the lecture, he called it like the path of the law, and where he introduced his famous bad man theory. So the bad man theory of Oliver Wendell Holmes posits that law is best understood from the perspective of a person who is only interested in the material consequences of legal decisions rather than moral or ethical consideration. So the bad man, to use Oliver Wendell Holmes' expression, is not interested in whether something is good or bad, whether something is just or unjust, fair or unfair. No. What he's interested in is that if I am caught, if I am arrested, or if I'm being held account for having broken or breached the law, what will be my fate? That which will be my fate is what matters to me, and not any other thing you people claim the law is trying to achieve in society. So that is the bad man theory. And of course, to a large extent, for many people in society, that is what is of concern to them. Okay, so this thing I am going to do, if I am being held legally accountable, what will be my fate? Will I go scot-free, or will I be in trouble, or something like that? So for a lot of people, according to Holmes, those are the things they care about. And he is of the view that this approach of looking at the law brings what he called a different version of what he called the predictive view of the law. How the legal rules are applied in practice and how they guide behavior rather than their moral or intrinsic value. So let me give a typical example. Sanctity of life, okay, is a very important value. Life is sacred and so on and so forth. So that's the doctrine of sanctity of life. It's a beautiful thing, that's good. But according to Oliver Wendell Holmes, for example, that it doesn't really mean anything. What really matters is that if the person said, okay, if I kill another person, right? Or if I cause injury to another person, what will happen to me? What will be my fate? What will be my situation? It is that which matters, and not the idea that, oh, life is sacred, so don't do anything which will end life or which will harm life. So that is looking at the moral or the intrinsic value. That is, is not a concern of the bad man. What the bad man really cares about is that, yes, if I am arrested or if I am being held accountable for having killed or having caused injury to another person, what will I suffer, or what will be my fate? That is what really concerns the bad man. So that is the bad man theory of law. Then, just like other people who will come about him, Wendell Holmes also had skepticism towards legal formalism, as we have explained, that it is absolutely misleading to try and deduce logically from established principle or precedent. So that is the syllogism we're talking about, without paying attention to social conditions or consequences. So let's take, you all remember the case of the Donegal and Stevenson, okay? So Donegal and Stevenson, we are told that there was a decomposed snail in the ginger beer bottle. And then the bottle was supposed to be, it wasn't transparent or translucent. I think it was supposed to be opaque, so you couldn't actually see. And the famous Lord Atkin statement, the neighbor principle and all that, led to the general principle of the duty of care. And yes, I mean, that is a beautiful principle. But then if you are to apply the realist thinking, they will say that let's look at the social context. What was situation of manufacturing at the time and situation of manufacturing now? In terms of standards, we have like the standards authority now and so on and so forth. So there are a lot of things which are taken care of. So it will not justify probably having a very broad principle as would have been justifiable many years ago because of maybe the state of society and so on and so forth. I mean, this is just a very a rough example, but just to let you know that for him, it's not so much about just looking at how the rules apply logically, but more importantly, the social conditions in which the rules are being applied, and then the consequences which they produce. Yeah, so he argued that judges make law and that their decisions are influenced by a variety of factors, including their own experiences and societal values. So when it comes to, let's say, a case involving abortion, okay? A case involving abortion, for example, judges who are, for example, Catholics, would definitely know how to interpret the law as whether the law protects the right to abortion or not. Those who are not will also say that the law does. I mean, that is just an example. And if you go to the United States of America, where these ideas originated, if you look at their society and you see some of these things really at work, that certain types of cases, you look at the background of the judges or the courts, and you begin to understand why they voted the way that they did in trying to decide those cases as it were. Yeah, I think we've discussed this. But Oliver Wendell Holmes' contribution is not only beautiful, it has also got its ugly side. So what are the criticisms? Now, some scholars argue that William Wendell Holmes' pragmatic approach to law and his emphasis on judicial discretion could undermine the predictability and stability of the legal system. Yeah, I think there's some truth in that, that if you take the message so far that we don't know the law, or we can't know the law until the courts have spoken, until the judge has applied it or pronounced upon it, then that is problematic. In Ghana, for example, we take Article 11 of our Constitution. It was about sources of law. So therefore, one would say that if you wanted to know the position of the law on anything, look at the sources which have been adumbrated there and follow them. It will help you to get to the relevant rules on any particular problem or subject matter. But then if we take the argument of Holmes so far that we don't know the law, or we cannot know the law until the law has been applied, until the court has pronounced upon it, then there will be problem of not ever having predictability and also certainty in society. And that is not good. And especially if you bring that thinking into the realm of commercial transaction, into the realm of commercial law and so on, society will never make progress, because when it comes to commercial transaction, there is absolute need for stability. And stability is made possible by certainty and predictability. People engage commercially, people engage in transactions because of the certainty that there are certain, there are certain things which they can take for granted as being in place. So we take, let's say, that the principles which constitute general law of contract or in the sale of goods, or principle which constitute the, when it comes to like payment, right, bill of exchange. If you look at the history of commercial law, there's what we call the lex mercatura. The lex mercatura, for example, will have evolved as a result of practices of merchants. Okay, that's what we call like the law of merchants. It's the practices of merchants which over time become so crystallized that actors in the field of commerce can assume or take for granted that for these matters, that is how they are done. So if I am making my arrangement, if I am making my transactions on basis of these practices, I can be rest assured that other actors, right, within the commerce would also cooperate, because that is how it is. And if you look at most of the rules which constitute commercial law, contract and all that, they are premised upon these arrangements which ensure predictability. So therefore, if we are going by Holmes' thinking, you will notice that it will not be possible to actually have commercial transactions or have people to have meaningful engagement. Yeah, so that is the one big challenge which may be leveled against Oliver Wendell Holmes, and for that matter, American legal realism. Okay, another contributor to American legal realism is K.N. Llewellyn, what you usually call the Karl Llewellyn. So Karl Nicholson Llewellyn, Karl Llewellyn, and he wrote extensively. He also made an important contribution to what Oliver Wendell Holmes has started. So according to Karl Llewellyn, legal rules are not as important as some legal theories claim they are. It is how a rule works that determines its significance. And they are not to be thought of solely in terms of verbal formula. Like verbal formula, as we saw. Okay, you have the rule plus facts, then this and that. No, that rules are not supposed to be conceptualized or understood in that way. But more importantly, we should look at rules in terms of what they do. So rules are what they do. So Karl Llewellyn will emphasize that any study of rules which ignore ideology and ideals is a mistaken approach, because that will mean that you are ignoring the reality of law. The reality of law is grounded in ideology, is grounded in ideals or certain biases. That is the reality of law. And that is why, if you look at, I'll give you an example. If you look at our own constitution, the article 129, if I'm not mistaken, I don't have my constitution right. Article 129, among other things, will make the point that the decisions of the Supreme Court are binding on all courts, that the Supreme Court is supposed to follow its own decision, except that it may depart from its decision where it deems such departure to be fit. where it deems such departure to be fit, then it may depart from it. Now, if you look at that provision critically, you will notice that the framers of the Constitution appreciate that, yes, the Supreme Court is the apex court of the country. Their decisions are binding on all courts and adjudicators within the legal system and all that. However, there may be a need for certain decisions they have made in terms of the principles espoused to be departed from in order to achieve a greater good for society. And that is why that provision is there. So therefore, maybe you have like a panel of Supreme Court judges who had a particular way of understanding certain aspects of society or life. And certain matters came before them. And they reason in a particular way and arrive at the certain decisions. Now, many decades later, you get another set of people who are now manning the Supreme Court. And some of these people, their way of looking at life, society, is completely different from the people who manned the court, let's say, 3 decades ago. And a certain matter which has been decided in a particular way, and those who man the court now, they have a completely different view about it. So that is a possibility for them to make a departure. And when they made the departure, they will try and justify it as, for example, being no longer good for society, and that is why it will be this or that way. But according to, let's say, realist thinking, it may not necessarily be so. It may just be that the ideology and the ideals which the current set of people who man, let's say, the Supreme Court, they reflect is probably fundamentally different from the same way in which people who man Supreme Court, some 3 decades ago had, and so on and so forth. So that is the point. So Karl Llewellyn, just like Oliver Wendell, to make the point that it is operational significance of rules of law which has to be considered, and not just the rules themselves as it were. So Karl Llewellyn's contribution to realism was founded on the concept of functionalism. So functionalism, just from what we said, that it is the operational significance, the law in action, the law functioning, which matters. So his contribution is premised more on the concept of what? Functionalism. So for him, that is for Karl Llewellyn, law was always a means to social end and not an end in itself. So the law was an engine which had to be examined in terms of purpose and effect. In terms of purpose and effect. And he will make the point that law has certain purposes and not a value in itself. And that is why I say that the law is a means to social end and it's not an end in itself. So in order for society to survive, certain basic needs must be satisfied. And this engenders conflict, which must be resolved. So to some extent, just as maybe natural law, if you remember, they said that law is teleological, is purposeful. And Fuller also told us that law is a conscious effort of subjecting human conduct or society to certain processes, or to certain purposes, which the law seeks to achieve. So, in a similar vein, Karl Llewellyn is also saying that yes, law is supposed to serve a purpose. So, in Llewellyn's approach of interpretation, like when it comes to interpretation, law constituted an institution organized around performance of necessary social tasks. So there are certain tasks. Already has made the point that yes, you cannot rule out conflict from society. And for those of us in Ghana, especially for I think the Akan speaking people, there's an expression that a cynic at Remakora, a kontoka, like you tell like the tank, right? The tank in your mouth, the teeth and the tank, they are in the same environment. So it's safe to assume that they are neighbors or they are siblings, isn't it? Where your tongue is, where your teeth are. And one will expect that they will coexist in harmony. But from time to time, you see your teeth biting your tongue. And you sometimes, depending upon how severe it is, you may even shed a tear or something. Nobody has beaten you, but there's a war going on in part of your part, isn't it? So conflicts will definitely occur in society because of our different interests, and you want to satisfy them. And then Llewellyn said that being the case, there are certain social tasks which are supposed to be performed. And these social tasks are performed through instrumentality of law. So law is mobilized to enable the necessary social tasks to be performed. And that is why Llewellyn would say that if we take an institution such as law, it's made up of techniques, precepts, rules, and ideology. So law has got its techniques. You have the legal methods and so on and so forth, the various procedures, right? Precepts, certain ideas that it espouses, rules, and also ideology. Ideology. So if you take our society, for example, there was what you call the National Cathedral case, if you remember. And I think there was also this argument that the state sponsors people to go on Hajj. And some people were also arguing that if that is so, then there's nothing wrong for the state to also have a major building for the Christian community called, if you like, the National Cathedral, as it were. Then some will put up the argument that if you do that, it's like you are complicating the relationship between state and religion. So we come back to the issue of what? Ideology. How far should the law intervene as far as religion is concerned? Then, so law serves certain fundamental functions. And Karl Llewellyn, in his work, called them the law jobs. Law jobs. And these law jobs are the things which are supposed to be accomplished if law is functioning properly as an institution. So what are some of these law jobs? Llewellyn identifies 5 law jobs. 1, the disposition, that is the adjustment of trouble cases. And perhaps, according to him, that's the most important of the law jobs. Already has made the point that conflicts or disputes are part of society. We cannot avoid them, but we need to manage them when they come. And how do you manage conflicts? You manage conflicts using the instrumentality of law, as it were. So it is work of a basic nature, which must be done properly and in sufficiently large number of cases if society is to remain a coherent unit. So just imagine, there's a very good example, but for some good reason, I cannot discuss it with you. Otherwise, that would have been a very good example. Just imagine all the manner of disputes which come up, conflicts which arise in our society. Assuming we do not have the law courts, which will actually adjudicate, and people have to find their own way of solving the problems. You can imagine how chaotic society will have been, isn't it? So therefore, he considers the law job of disposition, adjustment of cases as, if you like, one of the most important tasks for the law. So work of this type, that is the resolution of disputes and settling of grievances, acts as a test to decide which legal rules prevail in the real world. So through the resolution of disputes, rules are deployed, and at the end of the day, the outcome of the dispute will let us know which of the legal rules is actually holding sway as the governing principle, which we should all live by. Another law job which Llewellyn identified is the preventive channeling of conduct and expectations in areas of actual or potential conflict. And according to him, this is intended to head off collision and consequent disputes. Yes, having society made up of different people, different interests, and the interests may clash here and there. It is necessary for law to have that preventive posture. How? Law should be mobilized in such a way that people's expectations and interests are managed in a way which will not escalate into a full-blown dispute that may have to even make their way to the courts and so on. And if we look at, we can have examples. Let's take the law on wills, okay? Someone, you are doing succession and equity, you've learned about statutory will and all that. And even our traditional non-cooperative will in Samanso and all that. So someone dies, or no, someone knows that he or she will die. He makes a will to determine how his affairs and assets should be distributed or disposed of when he or she is no more. Now, in absence of such a testamentary arrangement, and also in absence of a default law, such as interstate succession law, PNDC law 111, which says that if you do not make a will and you die intestate, then we are going to have these default rules, which will be used in distributing your estate, that is, properties that you left behind, and so on. Now, imagine we don't have any of these two. So we don't have a law which enables you to make a will. You haven't made the will. We don't also have a law which, for example, has stipulated predetermined rules regarding how the estate should be distributed. And then the person is gone. He left behind so many siblings, a wife, children, or things like that. Everybody will be jostling to get what he or she wants from what the person left behind. You can imagine the chaos which will ensue. But having a law which says that, okay, you can make a will, or which says that if you don't make a will, we have these predetermined default rules which will be used in distributing the estate. You have actually managed people's conduct and expectation, and you have avoided potential conflict. So that is another law job, the preventive channeling of conduct and expectation. Of course, we can give so many examples, just like when it comes to national elections, right? If you look at the Constitution, we have a formula, the threshold which should be met before we can say that you can be declared the winner of the presidential election or the parliamentary election, as it were. So once that is there, you use that to manage conduct and expectation. In absence of that, there will have definitely been collision and consequent dispute, as it were. So the third law job Karl Llewellyn identified is the allocation and exercise of authority or jurisdiction within society. And he refers to this as arranging the say and its saying. So that's the third law job, arranging the say and its saying. So say as in S-A-Y, arranging, the say, that is what to say, and also how it is said. So arranging the say and its saying. It results in the settling of procedures which legitimize subsequent action. So we have said in this class before that it's not enough for you to wake up early in the morning, go and sit in the courtroom and say that you have a case. You can be the first person to arrive in the courtroom and probably be the last person to leave. Your case will never be called because you have no case before the court, isn't it? Because there's a procedure which you follow before your case can become part of the cases on the cause list. The cause list refers to a list of cases which will be called in a particular case, in a particular court on a particular date. So you have to, make use of the systems of judicial decision. And that is why he's saying that a law job is arranging the say and its saying. at the location and exercise of authority or organization within society. So who has the power to do what? And how is that power exercised? Another law job, the provision of directive and incentive through the organization of society as a whole, which involves the total effect of the three previously listed law jobs. So we've talked about the adjudication, we talk about preventive channeling, we talk about the systems of decision. So he's saying that another law job is to create the necessary arrangements which will motivate people to cooperate so that the other three law jobs that we talk about can be achieved. And 5, the provision of an appropriate heuristic method, which involves law as technology and embraces the maintenance and improvement of law structures, the traditions and skills of the official craftsmen of the law. So here, we are talking about the fact that law should also see to providing the necessary support system which enable law to perform all the law jobs that we have been combing through. And this would involve having a system which ensures training of those who are going to actually mine the institution. So legal education. We're also talking about sharpening the skills, continuing legal education, judicial education. We're also talking about having law reform. We have the Law Reform Commission. We're also talking about having law report. So we have like the law reporting. So these are the law jobs which Karl Llewellyn identified. So to Llewellyn, as we have said, the most important job, the disposition of troubled cases. Yeah, so because of time, we have to leave him and say a few more words about Frank Jerome, another American realist. He was also a judge and a scholar. So he added another layer to American legal realism, and he made a distinction between rule skeptics and fact skeptics. Yes, rule skeptics, we've made it already, but the fact skeptics is probably the new one he's bringing. So rule skeptics or rule skepticism, what does it entail? Rule skeptics are concerned with the appellate courts, and they omit the unpredictability in the judicial process. That is to say that for the yeah, so we have those who think that what we should be concerned about is really about the content of the rules as pronounced upon at the higher level of the court hierarchy. So that is like maybe like the appellate courts and up to like the Supreme Court, because they think that that is where the law is actually pronounced upon in terms of precedential value. So therefore, let's say that we take like Ghana, you said that, okay, the Supreme Court decisions are binding on all courts. So in terms of like what the law really is with respect to content and all that, we have to look to the decisions of the Supreme Court or the Court of Appeal as it were. And the fact skeptics, on the other hand, are concerned to uncover the unconscious forces that affect the discovery and interpretation of the facts of a case. So I gave you example that if, let's take a jurist, for example, right? Let's say you are serving in a jury, and in the jury, you are trying a case of, let's say, a rape. And let's say you are a female, you've been raped before, or you nearly had such an experience, but the person did not succeed, but you came very close to it. And you are serving as a member of the jury who are doing the trial. Now, when it comes to finding of facts, making a determination as whether the person consented or did not consent, whether the person did this or not, that these are facts, okay, which you are trying to establish. So the fact skeptics say that there are certain unconscious forces, influences, which you yourself, you may not even be directly aware of, but they are there. And those factors are going to influence how you resolve these questions. So therefore, you may readily join the group which you say that, yes, the person really committed the rape. And you are voting in favor of that because of a certain unconscious force operating on your mind. The fact that some time ago, you came close to such an experience, or you were even a victim, and so on. So that is the point being made here. And Jerome Frank, he says that, yes, fact skeptics is also a very important aspect of legal realism. And of course, fact skepticism, that one we have to look at the trial court, because facts are actually determined, mainly at the trial courts. So that is where evidence is what is taken. When it comes to the appellate courts, either the High Court serving as an appellate court over the district court, or the Court of Appeal serving as appellate court over the High Court, Circuit Court, or the Supreme Court serving as an appellate court over the Court of Appeal and all that. When it comes to the appellate work, the focus is just on the record of appeal. So no, as a general rule, no fresh evidence is taken. The evidence has been taken already. We just want to find out whether they were properly considered before a certain conclusion or so was arrived, and so on. But at the trial level, you are now trying to build the fact, determine whether something happened or something did not happen, whether something is true or not true, and so on. And that is where the fact skeptics say that the unconscious forces may operate to affect how you discover and interpret facts of a particular case. So to Jerome Frank, certainty of law cannot be achieved through legal rules. And for that matter, he will identify himself with the fact skeptics and made the belief that various prejudices of jurors and judges crucially affect the outcome of a case. So I give you a typical example. Many years ago, I think that was in 1997, when I was a student at the University of Ghana, first year, we were told that a particular lecturer, a professor of geography, I'll not mention his name, whose wife was once killed on Legon campus when a student was driving a car and knocked the woman down. And since then, that person, that is the widower, the lecturer, has developed a very strict, unfriendly attitude towards students. So I'm just citing that for you to understand how these unconscious forces or prejudice actually operate on the mind of people for them to behave the way that they do, and so on. And the same thing applies. The same thing applies when it comes to adjudication, and that is the point Jerome Frank is trying to make for us. So let's pay attention to that. So Jerome Frank argues that law cannot be separated from the decisions of the courts. It is therefore necessary to understand the basis of judicial decisions. And we can only do this if we carried out an investigation of a variety of factors, such as emotions and hunches, like the background that I'll be telling you. And the law is in relation to a set of facts, a decision of the court relating to those facts. And until the court has given its decision, no law concerning those specific facts is in existence. And this is very important. So when you take judicial decisions, more or less, whether explicitly or implicitly, that is whether articulated or unarticulated, you can see two components of every judicial decision, so to speak. And these components may be so articulated clearly that you don't need to struggle to see them. But in some cases, so they may not be so articulated that you may need to open your eyes well before you see. And what are these two? Every decision has got what we call the factual side and also the legal rule, and application of the legal rule to those factual side. And that's the point Jerome is trying to make, that if we take any set of facts, in relation to cases, the court will have to make findings of facts. The court will say that I make a finding that X, Y, Z happened. I make a finding that D never happened. I make a finding that K was this, M was not that. And the court will be guided by the law of evidence, right? To be able to make those findings. And once those findings are made, that is, these are the facts which the court accepts as properly established facts. If these are the facts, what does the law say? So now you are going to apply the law to the facts that you have actually found or established. And that is why Jerome Frank is telling us that how you arrive at the facts as very important as even how you are going to apply the law to the facts. Because arriving at the facts means that certain things will be rejected, certain things will be accommodated. So how you reject certain things as not having really happened, or accepting certain things that haven't happened, all those things are influenced by certain unconscious forces, certain biases, which may not even be obvious to you, but may be lurking somewhere at the back of your subconscious. So that is the point Jerome Frank is telling us. For that matter, the law is also essentially uncertain. And Frank will argue that rules are mere words. They are mere words. In any event, the court will indicate what rules mean, whether contained in a statute or implied in the opinion of some other court. And of course, just like what we learned from Holmes and also Karl Llewellyn. So rules are not to be found at the basis of a judge's decisions. Rather, those decisions may be arrived at before he finds a reason for them. And I told you this at the beginning of this class, that some people hold the view that when courts or tribunals or quasi-judicial bodies or anybody playing the role of adjudication, the entity may have maybe a particular decision or particular destination they want to get to. But you must use the law to rationalize or justify how you arrive there. And that is why Jerome Frank is saying that those decisions may be arrived at before he finds a reason for them. And sometimes we see this even like in the Supreme Court, especially so, and not only in the the Ghana Supreme Court, but some other places as well, where you filed your case and all that. You have a judgment conference. They have read all that you have said, they have listened to you. And then their mind is made up as whether what you are saying, they should agree with you or they shouldn't agree with you. They should grant it or they shouldn't grant it. So they can say that, okay, we have dismissed the case of the plaintiff or the applicant. We shall give our reasoned judgment in 2 weeks or in 3 weeks. So here, the decision is there, but now they need to bring the arguments which justify the decision that they have given, as it were. So Llewellyn makes the further observation that knowledge of the rules alone is of limited value in predicting the outcome of a trial. It is therefore necessary to turn for guidance to a study of other matters. So we shouldn't be interested in studying only the legal rules. You should also be interested in studying other matters. You should study psychology. You should study the background of the judge, the jury. We should be interested in the books that they read. We should be interested in the type of music that they listen to, probably the type of movies that they watch. Because all these things are important matters which will shape the thinking and then the predilections of the particular jury or the judge, as the case may be. So therefore, the prejudice of a jury may be of disproportionate significance in the outcome of legal proceedings. Of course, every legal theory has got its own downsides, and for that matter, American legal realism have been criticized for being oversimplification. Now, if you look at even the three proponents that we discussed, Wendell, Holmes, Karl Llewellyn, and then Jerome Frank, the way that they have espoused their ideas, you notice that it appears so simple, but law, and for that matter, the legal system, is much more complex than that. Again, they seek to purge the law of all moral terms. But that is a big problem. After all, can you imagine law without any moral content? If we look at hard concept of law, the closing chapter, where he made the concession that in his view, human beings, we have certain unique challenges. So we can never completely get morality out of what? Out of law. So pragmatism and empiricism in the final analysis are abnegations of the search for truth. It's not really a complete, it's only approximation. It's only approximation in trying to arrive at the truth. And if you use the sociological approach, for example, those of you who do social science research, you know, we always have limitation as part of the methodology, like at the end of it. What are the limitations of your studies? Meaning that the search for truth is never a perfect one. For that matter, to regard law as what the court will do, in fact, is oversimplification, which disregards the phenomenon of legal error and appellate review. I'll give you 10 minutes break, and then we do Scandinavian Realism before we come back to company law. So 10 minutes break. Yeah, so we would like to continue with Scandinavian Realism. There are a few points about the criticism of the American Realism, but I think when I give you the slide and you read it, you take more points for purposes of your examination. Yeah, so Scandinavian realism, we've introduced it as part of the general introduction when we started, and is associated with the scholars from Sweden, Denmark, and Norway, and that is why we call it the Nordic legal realism, the Nordic countries, Sweden, Denmark, Norway, and even like Finland as well. The movement is characterized by a sustained attack on metaphysical nature of law based on their reading of Roman law. And let me put this in perspective. You notice that Sweden, Denmark, and Norway, all of them, their legal tradition is the continental legal tradition, what we call the Roman Dutch legal tradition. So their legal system, their ideas about law, legal institutions and all that are shaped by what Roman law taught and then what legacy Roman law left them. So therefore, according to Scandinavian Realists, exposition of law has been unread as though law is different from the physical world. In other words, they are worried that the way other jurists, earlier philosophers, legal thinkers have approached law is that law is removed from the physical world in which it's supposed to operate, in which it's supposed to be situated. So that is their concern. So like their American counterparts, that American realism, Scandinavian realists are concerned to explain law as it is. Law as it is. And what are the essential features of their version of realism? I mean, the Scandinavian, what are the essential features? One, rejection of metaphysical speculation. They hold the view that reality may be discovered or analyzed only through an investigation of the fundamental facts of the legal system. That is how you actually discover or arrive at reality or truth. Now, the implication for this is that assertions which are incapable of proof are nonsense. That is, they don't make sense and they are to be rejected. Scandinavian realists also makes the point that our morality is created by law and not law for morality. So just like the chicken and egg paradox, did we get the egg first, which hatched into the chicken, or did we get the chicken which actually laid the eggs? With respect to law and morality, Scandinavian realists hold the view that it is one-way traffic. It is law which creates morality, and not morality which actually gives rise to law. So they maintain that natural law is an illusion. And remember, natural law is heavily steeped in metaphysical abstraction, a priori reasoning. Now, Scandinavian realists are saying that natural law is an illusion. It's not real. It's not something which is concrete. And for that matter, jurisprudential arguments derived from natural law are unacceptable. It is also the point or the case of Scandinavian Realism that law can be understood in terms of sets of brain's responses to groups of stimuli. Now, when certain stimuli are triggered, how does the brain respond to those stimuli? Now, from that perspective, we can get a very useful understanding or insight of what law is or the nature of law. Again, Scandinavian realists emphasize that legal ideas are mainly the rationalization of social facts. They are nothing more than you trying to make sense of social facts. They also make the point that commands reflect illusions, ensuring obedience by their mandatory forms. So when you see commands, I'm sure your mind is going back to legal positivism, and especially the version developed by Hans Kelsen, if you remember his pure theory of law. And again, Scandinavian realists point out that values such as goodness are no more than the embodiment reactions expressing approval of a stimulus. That is a singular version of the stimuli. So as to whether something is good or bad, it's just a reflection of how we react to certain happenings in terms of emotional states within our psychic. So here you see psychology becomes an important part of their thinking. So let's look at some of the proponents. So we'll discuss Axel Hagerstrom. Axel Hagerstrom from Sweden, and an important contributor to what we call the Scandinavian legal realism movement. Hagerstrom is committed to realistic view of how law comes into being, rather than any metaphysical speculation regarding law. So he actually advocated that metaphysical abstraction should be destroyed when we are thinking about the law. And he rather believed that empirical analysis, which involves the acceptance of sense data or sensory data as a sole source of valid information, will provide answers to questions concerning the origin, nature, and functions of law. That if you want to understand the origin, nature, and functions of law, we shouldn't go too far. We should limit ourselves to only information which can be proved using our senses, our hands, our eyes, our nose, our ears. These are our senses. So if we cannot use our senses to verify a data which is supposed to help us to understand where law came from, or the nature of law, or the rule of law, or how law actually operates in society, then we should forget about it. That will be still gravitating towards metaphysical abstraction, and that is not what as a Hagerstrom and legal realists are interested in. They're interested in the empirical, something which can practically be established. Again, he underscored the fact that law is a necessary condition of organized social life within a state. So increasingly, you see almost all jurists agree that law is necessary. Society needs law. Hagerstrom opines that law is because it just has to be. Law is because it just has to be. It is a natural phenomenon. But the natural phenomenon here does not mean that you should let your mind go into the realm of natural law. No. Just trying to build upon the point that, yes, you can't have an organized social life in the state without the, the assistance or the instrumentality of law. And that is why he said that law is just because it has to be. You need law. So Hagerstrom continues that law is positive law made by human beings and located within physical reality in terms of social facts. And again, natural law theories, which we learned extensively last semester, according to Hagerstrom, must be rejected because they are false. And even if they are not meaningless, they are false. And the reason why they are false is that they locate law within God or state. They say that, of course, you saw natural law, scholars like St. Thomas Aquinas, St. Augustine, Cicero, Fuller, and even the social contractarians, or even Hugo Grotius, who will point to either God or state as being the source of the law. So that metaphysical or spiritual reality of ideals and values that cannot be conceived as alongside the physical reality is false, and that should be rejected. That is the teaching of Hagerstrom. So for Hagerstrom, it is impossible to identify any uniquely will behind the positive laws. That is to say that if you say like unitary will, some positivists will tell us that law is the command of the uncommanded sovereign, and for that matter, is the command is a reflection of the will or wishes of the sovereign. Now, Hagerstrom says that it's not really possible to identify any particular will, anybody's will or wish as being reflected in the positive law. And for that matter, the will of the sovereign, according to Hagerstrom, is a metaphysical idea that must be rejected or discarded as meaningless. You cannot locate it in concrete terms. You cannot prove it empirically. And we saw in Ghana, Article 1 of our constitution, sovereignty resides in the people of Ghana for whose interest and welfare the Constitution is supposed to be enforced and all that. Remember that. Now, if you are going by the orthodox approach or the orthodox understanding of positivists, that law is a command of the sovereign. For that matter, going to Article 1 of our Constitution, we, the people of Ghana, are the sovereign. Now, at the moment, the people of Ghana, we are over 30 million we are over 30 million or 33 million. So whose will is actually reflected in the law? Whose will is reflected in the law? So that is the fallacy Hagerstrom is actually exposing. And for that matter, as far as Hagerstrom is concerned, law cannot be conceptualized as a system of authoritative norms concerning rights and duties of persons. Rights, duties, obligations are meaningless concepts because they are not rooted in actual experience. They lack any empirical significance until particular situation, particular state of affairs are challenged. So not until you have a factual situation. What is being asserted as a right to something, or somebody having a duty, or somebody having an obligation, which has been met or has not been met, cannot be made sense of until it is tested within a certain factual scenario. And that is what happens. For example, somebody is saying that the land over there is for me, Black Acre is for me, and I was away, having acquired it, and I came back, and Mr. B has developed a portion of it. Mr. B says that, well, I have been on this land for over 12 years. And for that matter, my adverse possession has extinguished whatever title that you had. So I have the right to be on this land. I'm entitled to be here. Now you notice that the statement that I have the right to this property or whatever is vague until we assemble the facts. The fact relating to the fact of physical possession, the time that he or she entered into possession. Was there animus possidendi? Was there intention to actually lay exclusive claim and exclude even the original owner and all that? Until all these pieces of facts are assembled, we cannot actually appreciate any claim that anyone has a right to any particular parcel of land, as it were. So let's keep that in mind. And that is why Hagerstrom is saying that the term right has meaning only when associated clearly with remedies and legal enforcement procedures. Similarly, we believe that the term justice represents in reality no more than a personal, highly subjective evaluation of some state of affairs of which we generally approve. And that is why he said that it is where your brain is responding to a certain stimuli, as we noted earlier on. So justice, for example, is an empty word. as he would say, and is nothing more than an individual's personal subjective experience of it, as whether he or she agree with certain state of affairs or not. And people are persuaded to obey law as a result of conditioning. Conditioning means that as a result of grooming or socialization, right? Socialization. We are all socialized. That when you see red, when you are driving, you have to stop. When you see green, go. We are socialized that when someone's item is there, you cannot take it without taking the person's permission and all that. So here, our obedience of the law is a result of how we be conditioned, how we have been socialized, so to speak. And society accepts, because of long historical periods of training, that certain rights exist as a result of a series of particular types of events. We'll leave Hagerstrom and look at another Scandinavian realist, Karl Olivecrona. I'm not talking about Karl Llewellyn. Karl Llewellyn is an American, but this one, Karl Olivecrona. He was also a Swedish philosopher and made the argument that law exists in a factual sense only. So law exists in a factual sense only. And right away, that is an implied rejection of metaphysical speculation about law. And that is why he has made categorical claim that law exists in a factual sense only. That is, if you can factually establish it, then that is law. According to Olivecrona, the significance of words printed on paper or internalized in people's mind is that they form a link in the chain of causation, which results in certain causes of behavior. And he will give the analogy from psychology, that law is just a little more than a form of psychology. I mean, psychology, you know it, the study of how our brain operates, how we react to situations, our emotional states, and so on and so forth. So a symbolic expression for the fact that the human mind responds in certain ways to various forms of social pressure. Lawyers and officials read the laws enacted by the legislature. And by virtue of their conditioning, when we say their conditioning, that is their training. Now you're in the law school, you're in the law faculty. We are training you about how to find the law. We are training you about how to interpret the law, how to use the law. So you are being conditioned, right? And the lawmakers have made the law, and you, the lawyers and officials, including like the courts, because you have been conditioned, you have been trained, you are induced to act in particular ways. So the judge decides X, the policeman enforces X. So you go to the courtroom, certain cases are called, the judge listens, he or she put his or her head down, put certain things, you read them as his or her orders. And if it includes the fact that somebody should be taken to Sawam, in less than 24 hours, the person will be taken to the prison. So the judge decides, the policeman enforces. So that is how the society has conditioned us through our training, socialization, and all that. And that is the point Karl Olivecrona is trying to make. So to Olivecrona, a monopoly of force is required for the psychological basis of the law to be effective. And he suggests that the law is, in fact, the progenitor of many of our moral standards. That is to say that many of our moral standards trace their origin to law. And if you remember, at the beginning of Scandinavian Realism, we made the point that they see law as giving rise to morality, and not morality giving rise to law. And what Olivecrona is saying here is consistent with that early observation, that law is in fact the progenitor of many of our moral standards. We are at an early age conditioned into accepting that certain conduct is unlawful. So it's in your head, it's unlawful. Give you a typical example. You enter a market, people have lined up items on their tables that they are selling or in the supermarket. And you start picking and choosing whatever you need, and you just walk away. You don't ask for a price, you don't pay anything. Certainly, that is not how we are conditioned. So you not do that. You not do that, because if you were to do that, you yourself, you know or feel that the conduct you put up is unlawful. So the stamp of illegality lends these rules a particular power. Because within you, you feel that what you've done is illegal, is against the law. You not break it. And that is the point he's trying to make, that that psychological aspect also gives a certain effectiveness to law. It gives certain effectiveness to law. So that is the point that he's trying to make. So we quickly learn to internalize these rules, and they then come to be our standards of morality. And that's why they're saying that the morality is actually that given by law and not the vice versa. So I'll give you a typical example. We have the law against indecent exposure, isn't it? And part of it is that you cannot remove yourself completely naked unless we all come to the conclusion that you're a mad person, in which case, a mad person, you cannot worry yourself and apply the law. He or she has taken himself out of the realm of people who want to govern their life by law. So one of the easiest ways, if you want to avoid the law, is maybe become a mad person. Then that case, the courts, the police, nobody will worry you. But if you are not in that category, and you decided to, for example, strip yourself and all that, you know that that is against the law. And growing up, going to school and all that, you imbibe this particular thing. And you will not actually, apart from maybe when you go to the beach or you wear bikinis or something like that, you will not ordinarily, like when you are just in ordinary, normal public space, completely expose yourself, as it were. So there will even be no need for the law against indecent exposure or dressing, for example, to be applied, because You have been socialized, you have been brought up in a way which has made you internalize this particular rule and has more or less become your standards of morality, as it were. Again, Olivecrona also was of the view that origin of law was simply a matter of fact. And that is why he earlier said that law is just the way it is. So law is originally coercive. So sanctions are provided for infractions of the rules. Individuals are then faced with the choice between compliance and disobedience. Over time, this process becomes too onerous for most of us, so that both the temptation of committing the act in question, on the one hand, and the fear of the possible sanction on the other, are sublimated or repressed into our subconscious mind. So we spare ourselves the trouble of every now and again having to make that internal deliberation. Should I do this as the law expects me to do so that I avoid this particular sanction? Or should I ignore the law and psych myself up for this particular punishment? After all, what? If I go to prison at all, I go for 6 months or 2 years, I come back and continue my life. Now, according to Olivecrona, in the beginning, we'll be going through this series of deliberation. The dilemma: should I obey the law and avoid stipulated sanctions, or should I embrace the sanctions and disobey the law? We keep on doing this, and it will become so regular and somewhat burdensome that our subconscious mind will just get this embedded. It will just get stored there. So in our conscious mind, you will simply retain an imperative symbol such as, you shall not steal. The rule has therefore been internalized, and there's now normally no need for threat of coercion. So initially, we have the coercion there, and we go through a series of cycles of deliberating whether to obey or to disobey the law and all that. And the repetitiveness of that exercise gets into our subconscious that we no longer have to even worry. And our system will just register a particular option, and then we are in obedience. So therefore, Olivecrona makes the point that the rules of law are independent imperatives and not commands. They are independent imperatives and not command, as the positivists will have us to believe. So he makes the point that it is false to think of law as the commands of a natural person. For no human being could go about commanding all that is contained in the law. Of course, if you look at the various laws that we have, if you take the model that law is actually expression or is a command, so you ask yourself, at what point did who actually spell this out? And is it realistic? So that is a point that Olivecrona is trying to make, that there is no personal relationship from the issuer of the command and the party to whom it applies. So the rules of law within a legal system are now largely independent imperatives that are passed through a series of recognized formal activities. Citizens give obedience to such imperatives because they have been conditioned to behave in such manner. So just like when the ambulance, you hear the siren, okay? If you hear the siren on the road, when you're driving, instinctively, you want to yield and make way for the vehicles which are coming. But that's how you'll be conditioned. We can give so many examples, or you can work out your own examples which validate the claim of Olivecrona. So custom, tradition, feelings of social solidarity and duty, and the residue of generations of historical development combine to assure the binding, non-optional character of independent imperatives. So our various custom, traditions, feelings, cooperation which exists between us as members of society, we interact in a way which make all of us find ourselves obeying what the law has actually prescribed without even being aware that we are being obedient to the law. So that is the point Olivecrona is trying to make. So the reality to which law must correspond consists of the psychological reactions of individuals. How people's brain respond to certain things. So these psychological reactions are the ideas of imaginary actions and the sensations of compulsion and restraint when a provision is brought to our auditory, that is our hearing, or visual, that is our eye, attention. So you see how Olivecrona is making use of psychology to explain the nature of law, and especially how the law is obeyed in society. So he classified law into voluntarism and non-voluntarism. And he makes the point that a proper theory must be a non-voluntarist or realistic theory of law, where legal rules are conceptualized as independent imperatives to be distinguished from commands. And then he will treat natural law and positive theories as belonging to the voluntarism, because in his view, natural law and positive law theories claim that law is the expression of the will of the supreme authority. And they only differ with respect to locating the supreme authority in God or the state. So he's trying to say that, yes, for as far as he's concerned, positive law and natural law theory, the difference is not much, because fundamentally, they all recognize the law as coming from a certain supreme authority. And the supreme authority, maybe one who say that is the one who say that it is the the state. Another will say that it is the Almighty God, or as it were. But the bottom line is that they all see law as expression of the will of the supreme authority. And that is why he's saying that they are, if you like, voluntarist theory, as it were. And then another Scandinavian legal realist you want to touch on before we draw the curtain down is Alf Ross. Alf Ross is from Denmark, and he believed that just a second. Yeah, so I was making the point that Alf Ross is attempting to call him Alfred, but it's not Alfred. That is a typical Nordic name, Alf Ross. He from Denmark, and another important contributor to Scandinavian realist thought. And he held the view that jurisprudence, or legal philosophy for that matter, is an empirical social science which takes the form of a system of normative rules. Normative rules in terms of prescribing what should be done or what should not be done. That is for norm. And validity, and of course, that also follows that law is a system of normative rules. Now, when you see it like this, the temptation is for you to say that, then is it not saying the same thing as the natural law scholars? No, wait a minute, that is not exactly what he's trying to do. He's doing something else. So Ross argues that validity of law rests on the possibility of one being able to predict that the rules are likely to be applied appropriately in future disputes. It doesn't rest on transcendental notions. With transcendental notion is the same as the metaphysical abstraction or speculation. That is you trying to talk about things which cannot be grounded in reality or in concrete facts. Then my screen was frozen. Let me share it again. So Ross makes the point that legal rules governs the entire set of institutions and agencies through which actions ascribed to the state in its legal capacity are undertaken. So here too, we see the emphasis on necessity of law in the society. Just as other legal realists have said that in a socially organized life in a society, you need law to be able to achieve that. And here too is saying that yes, you have various institutions and agencies, and the state functions through these institutions and agencies. The police, the authority that they exercise is the state, which is acting through them. Members of parliament, the authority that they exercise is the state acting through them. The chief director in a particular institution or the CEO in a state organization, the various prosecutors, the state which function through them, the courts and all that. So the primary rules which are followed with regularity and which may exist as psychological facts only, as we have seen previously, informing citizens as to how they are expected to behave, become binding. So there are a lot of things which we have imbibed into our system, and we follow them without even questioning them. So that is the point that he's making. So now we have Ghana card, for example, okay? Children who were born the last 5 years, the last 10 years, they may not even know or understand the law which we made, leading to the adoption of the Ghana card. But you go to banks, you go to various institutions, and they require proof of identity. The preferred proof of identity for them is the Ghana card. Now, that becomes part of, let's say, that our way of living, that every now and again, you make sure that you get your Ghana card, or if it is lost, you get it replaced and so on. Or if the child gets to a stage that he or she can be given, we let him or her go and get. And you are doing it, it's become like a routine, become part of our life. There's a law which actually established that, but you are not doing it because the law has been read to you and then you know what the law actually teaches or stipulates. So that is the point being made here. The secondary rules specify sanctions and conditions under which they will operate. So yes, the primary rules have told you what is expected of you, what you are supposed to do, what you are not supposed to do, and all that. Okay, so where you don't do that, what is the outcome? Or what must exist before you can do that which you are supposed to do according to the primary rules? So predictability of the operation of the rules, what you call the experience of validity, induces confidence in them. Because these are rules, people have lived it and become so part of them. They know what state of affairs should exist before they do what, or they know if they don't do what could happen and all that. Now, that brings its own attendant confidence and an acceptability. And that is what we call the experience of validity. So to know the secondary rules is to know everything about the existence and content of law. So the secondary rules, which specify the sanctions and conditions under which the primary rules operate. And he's saying that if you know, because the secondary rules is what we let you know, okay, if you don't do this, what is the outcome? If you don't do that, what is the result? So the secondary rules are that which will let you appreciate that. And that is why he says that if you know the secondary rules, then you actually know everything about the existence and content of what? Of law, as it were. The last proponent we'll discuss, and then we are done with the legal realism, is A.V. Lundstedt. A.V. Lundstedt was a jurist from Sweden and also a lawmaker. He believed that metaphysical interpretation of the law ought to be rejected, just like other realists. And that which can never be proved is no basis for the investigation of legal phenomena. If something cannot be verified, then we don't have to waste our time and energy on it. Lundstedt argued that judicial concept of rights, justice, are illusory. They are not real, they are not concrete. Because there is no scientific method of evaluating their basis. They are mere labels pertaining to consequence of certain legal procedures. So justice is just a label. Right is just a label. In his view, law should be interpreted simply as the facts of social existence. So Lundstedt said that law should be interpreted as what? The facts of social existence. And the legal order is essential to the continued existence of society. So just like other realists, is also emphasizing the need for law. Maybe just one or two observations about the downsides of Scandinavian realism. As we will notice, Scandinavian realism tries to move away from metaphysical interpretations of the law. All of them is running through. But if you examine closely, they seem to have substituted their own neo-metaphysics. So just as we say that they have actually ended colonialism, and then they introduce a new version of colonialism, which we called neo-colonialism. That is the point being made here, that yes, they said that let's abandon formal metaphysical interpretation of the law, because that is not rare. But if you examine some of the proponents closely, you notice that it's like they are evolving, if you like, their own version of that which they have rejected. So their search for essential characteristic features of the law appears to presuppose a transcendental phenomenon in the same category as the ultimate essence of law, associated with some natural law doctrine. Because as soon as you decide to find out, are there certain essential indicia or features of law, you are in the realm of what in philosophy called essentialism. Essentialism in philosophy is an attempt to try and get certain, if you like, irreducible elements which constitute a phenomenon. So if you are also searching for essential characteristic features of the law, then in a way, you are still coming back to that which you were complaining of or trying to run away from, as it were. And finally, the view that law creates morality, which a lot of Scandinavian realists have actually propounded, appears to be contrary to historical evidence. There are a number of examples we can cite which suggest that morality was probably there before law responded and not the other way around. So let's take the widespread abhorrence of murder, right? And the moral imperatives which the offense or the rejection of murder reflects. Now, societal abhorrence of murder actually existed before the law on homicide. And it's not the case that because of strict legal rules relating the consequence of unlawful homicide, like murder, then people avoid killing other people. No. I think historically, it will be difficult to sustain such an argument. On the other hand, if you look at the history of law, you have so many examples where lawmakers bow to pressure of the strong, morally inspired feelings of citizens. Let me give you another example. This LGBT thing which is going on, right? law, anti-gay marriage law and all that, you see how societal pressure is really strong. And I want to believe that if there were to be a referendum in Ghana, I will not be surprised if more than 50% of Ghanaians agreed that that law should have been passed. Now, if you take that view, it is not that law which is going to, for example, bring about whatever is enacting. Whatever is enacting is already there. The law is only trying to reflect that which already exists. So that is a point we are making, that the claim by Scandinavian Realism that law creates morality and not the other way around is a claim which one may find it difficult to sustain at all times. In some respect, yes, we may be able to sustain it, but in other respect, it may be untenable, as it were. Yeah, so if you have questions, we will take that and we'll move on. So if you want to speak, you can just raise up your hand.